Gregory Stafford.
Thank you very much, Madam Deputy Speaker. And as a member of the Mental Health Bill Committee, I had the opportunity to closely examine the development and scrutiny of this bill. Working alongside my opposition colleagues, we sought to strengthen the legislation, particularly in relation to safeguarding children and ensuring robust protections for those admitted under the Mental Health Act framework. Given the shortness of time, I only want to speak about Amendments 41 and 42, which make a vital clarification that for any patient under the age of 16, the nominated person must have parental or guardian responsibility unless there are clear and established safeguarding concerns. In essence, it ensures that parents remain the lawful decision makers and the first and most natural safeguard for their child's welfare. Let us consider for a moment what is at stake. Imagine a vulnerable 14-year-old girl frightened and confused during a psychiatric admission. In that moment of distress, a well-meaning adult, or worse, someone with a hidden agenda, could persuade the child to nominate them as their representative. That individual would then gain legal powers to object to treatment or discharge decisions, while the parents, the very people who know the child best and have both a moral and a legal duty to protect them, could be sidelined. Once such a nomination is witnessed, it carries legal force. The rights and responsibilities of parents could, in effect, be overridden. And while that might sound hypothetical, it isn't. Family courts have seen precisely how manipulative individuals exploit vulnerable young people. Groomers, traffickers and abusers thrive in the grey zones of the law, and if we are not crystal clear that only a court may displace parental responsibility, then we risk leaving the door ajar for such exploitation. So I ask the Minister in his wind-ups, can he assure the House that no child under 16 will be permitted to override parental authority simply by nominating somebody else without a full and proper judicial process? The bill does have fallback provisions, and they are, of course, welcome, but they are not watertight unless the law explicitly confirms that only a court can transfer or restrict parental rights.
Will you give way on that point? The member makes an excellent point, because the only two protections that I could see in Schedule 2 are the fact that there's an age requirement and a stipulation not to be disqualified by a previous court order, and then the witness specifically. There is therefore no forward preemptive way of protecting people, which is why this amendment is so important.
My honourable friend is absolutely right, and both he and I made these points at the Bill Committee stage, and I'm surprised that the Minister doesn't see the risks here, because that safeguard that my honourable friend talks about must be beyond any doubt, and this amendment in his name provides exactly that clarity and prevents any kind of unrelated or loosely connected individuals from stepping into a role that rightfully belongs with both a legal duty and an emotional bond to the parents or guardians. It preserves that fundamental principle that parents should not find their role diminished by accident or administrative oversight. Madam Deputy Speaker, as I said, this isn't an abstract risk. It is a very real and foreseeable consequence of this unclear drafting. These amendments don't weaken the rights of patients, not at all. It strengthens the protections around them. It ensures that in modernising this law, quite rightly, we do not inadvertently undermine the oldest and most important protection of all, a parent's duty to safeguard their child. And we must ensure that the state can only curtail that right under the strictest judicial scrutiny, with evidence tested and the child's welfare paramount. In doing so, we will make this legislation not only legally sound, but in my view, morally right. Briefly touching on new clause 31, which would require local authorities and ICBs to supply a fully costed plan to ensure they're able to provide adequate community services for people with learning disabilities and autistic people, in the name of my honourable friend from Hinckley and Bosworth. I support this entirely. Madam Deputy Speaker, as the Vice Chairman of the All-Party Parliamentary Group for SEND, and from speaking to groups such in my constituency, such as Last Wednesday and Growing Hope, I know the process around SEND is so complicated and isn't fit for purpose. And fortunately, we have a chance to help it slightly within this bill. So I ask the Minister, please do support this amendment, this new clause, in the name of my honourable friend.
Sojourn Joseph.